Okay. Now, Rebecca, you can officially take it away and I will get myself out of here.
Well, I first wanted to start by thanking Sophia and Ari for setting this up and inviting me. I also wanted to say thank you to Cassidy Stoneback, who's on here. She is my firm's LGBTQ plus outreach coordinator, who's been working with Sophia and Ari to organize today's program. So thank you all for coordinating this and inviting me. I'll just briefly introduce myself to you all, and then we'll jump into some of the nitty gritty of all fun things with legal issues. So my background is I used to practice law at a big firm in DC with 500 attorneys. I know there's some lawyers on here as well, and I was working crazy hours. I have 3 kids and wanted better quality of life, and wanted also to do more work with families and small businesses, and that's what I do now. So I left in 2011 to start my firm. My firm does work throughout Maryland, DC, and Virginia. We have offices in DC as well as in Virginia. We have 33 people total, 16 of whom are lawyers, all of whom actually are women. And we focus really on 3 things. We do wills and trusts and probate. We do family law and litigation. And then we serve as general counsel for a couple thousand small businesses and nonprofits throughout the region. And one of the things that we're going to talk about today is kind of dispelling some myths that people talk about a lot. I get tagged on social media posts all the time where people are asking questions about legal issues that come up. And 9 times out of 10, I read through the thread, and most of the advice that's given is just wrong. it's not based on DC law, and it's not relevant. And people give out advice that they don't know what they're talking about. People ask me a lot, what do I think about LegalZoom or Rocket Lawyer and, all these kinds of online legal sites. And I jokingly and not jokingly say, I love these sites. I think these sites are great. I make a lot of money fixing problems caused by these sites. So be careful. Anytime you see somebody recommending to go online and create something using an online legal tool, beware. What people always say to me, oh yeah, I paid $200 and I created something and it was fine. There were no problems. My question is, how do you know there were no problems? You're still alive. So the documents have not been really put to test. So just kind of be careful is my first advice. As we're having today's conversation, I want you to think about this through a couple of different lenses. So obviously you're going to think about it through the lens about your own affairs, getting your documents in place, getting your documents done correctly, to make sure that if something happens to you, that your loved ones will be able to handle things and things will be done smoothly. But you also want to think about if there's others in your life who you might be inheriting something from, or if there's somebody in your life who you might be taking care of, whether it's helping to deal with medical issues or legal or financial issues. Maybe that's a sibling, maybe that's a parent, maybe that's a friend who you are their emergency contact. You also want to think about this through that angle about who you're going to be helping to take care of and making sure that you're having these conversations with these people. So we're going to do this workshop interactively. I do this workshop about 40 or 50 times a year, and I do it a little bit differently depending on each group, but I try to make it as interactive as I can. So the chat is enabled. You're welcome to put questions into the chat, and I will kind of integrate the questions in. I'm also going to pause a couple times throughout when there are parts where I generally know that there are questions to see if there's questions you guys have. So let's jump in. The first thing people always ask me about is about taxes. How do I make sure that if something happens to me, that I can minimize my tax benefit, my tax liability? So what we're talking about here is the estate tax. So I'm going to first kind of explain a concept, and then I'm going to give you guys a true false statement, and you're going to put into the chat whether you think it's true or false, and then we'll talk about it. So make sure you guys are able at a place where you can enter something into that chat. So the estate tax is basically how the government will assess taxes on your estate after somebody passes away. However, it's based on certain thresholds. So let's talk about what that would be. How do you know what your estate is? Everybody has an estate. It's basically whatever your loved ones were to inherit if something happened to you. So in your head, we're not sharing these numbers, but in your head, I want each person to give some thought to these numbers and add them up in your head so you can come up with what your taxable estate would be. So the first one is life insurance. Life insurance does count as part of your taxable estate. I find that a lot of people don't realize that life insurance counts as part of your taxable estate. So for example, if you have $1 million life insurance policy, your estate is already $1 million. Even though, let's say it's a term policy and you can't access it during your lifetime, it still counts as part of your taxable estate. So, and if you're married, I want you to add that for you and your spouse together. So first one's life insurance. Second one is going to be a retirement account. Obviously here in DC, lots of people have TSPs and investments, like savings, checking, retirement, stocks, bonds, all of that. Are there any real estate properties? Do you have any equity in real estate? Are there any business interests? Are there rental properties? Do you have an LLC? Is there anybody who has you or your spouse have an interest in LLC or a business or something like that? So in your head, you're going to add up what those numbers are. So let's talk about, I'm going to give you my first true false, and then we're going to talk about it. So here's my true false. So get your fingers ready to be able to type into the chat and let me know if you guys think my question is true or false. So here's my statement. I live in DC and my estate is worth $4 million. Therefore, I do not have to pay any estate taxes when I die. I'll repeat it one more time and you guys can put in the chat whether you think it's true or false. I live in DC. My estate is worth $4 million. Therefore, I do not have to pay any estate tax when I die. Give you guys a minute to put your question answers in. By the way, if there's anybody in here who are CPAs and lawyers who actually handle this, you're not allowed to answer these questions. All right. So let's see. Everybody says false except for Jennifer. Jennifer, you get my first gold star of the day. So Jennifer Brown says it's true, and it's true. So let's talk about what we're looking at here. There's two issues. So the first is DC. And I'm assuming everybody here lives in DC, obviously. If for whatever reason you're in this group and you live elsewhere, send me a message. I can add in things for Virginia and Maryland. I'm licensed in all three jurisdictions. I'm going to assume everybody here is DC, but send me a message if you are outside of DC. So the estate tax threshold in DC is 4.25 million per spouse. So, if I had 4 million and my spouse has 4 million, then together we'd be under the estate tax threshold in DC. Now, one of the things that's unusual about DC does not have what we call portability. So let's say I have an estate of 6 million and my spouse has an estate of 1 million. Combined, we'd be under that collective 8.5 million. However, we can't combine it. DC does not allow what that's called, but combining it together is what's called portability. So my estate of 6 million, which is above that 4.25, would be subjected to the DC estate tax. And it's based on a sliding scale based on what your estate is. So that's something that's unusual in DC. Maryland, for example, has portability where you can combine it together. If you are above the DC estate tax threshold, there are things that we can do. So for example, for a lot of people, life insurance is a big piece of their estate. You have $1 million life insurance policy that jumps you up pretty quickly. So one of the things that we could look at is how do you put in place what's called an ILIT, an irrevocable life insurance trust, that basically removes your life insurance from your taxable estate. So if you are in this category where you do have an estate tax problem in DC, then we would want to take a look at how can we deal with this. And the DC estate tax threshold has changed a lot. I mean, up until, 5-8 years ago, it was 1 million. A lot of people have an estate tax problem in DC. Now it's jumped up a little bit. It's something we have to monitor because I don't know what it's going to do. Maybe it goes back down to 1 million. I don't know. So it's something that we have to kind of keep an eye on to see what happens. For federal, it's very different. So I'm going to give you guys a little bit of a historical context. So, 20 years ago or so, the federal estate tax threshold was 1 million. In the mid 2000s, it jumped to 5 million. That was indexed to inflation. It was roughly, I want to say maybe 5.8 million until the Trump tax plan went into effect in 2017. That jumped it up to 10 million per spouse. And there is that portability where if you're married, you can combine it together. And then it was also indexed to inflation. So right now it's, I'd say roughly about 13 million per spouse. So it's very, very high. So if you're married, maybe up to $26 million. Now, if the thing that to know about federal is that it's not staying here. This very high estate tax threshold is going to sunset in 2026. So we're only, I still am having a hard time remembering that it's 2023. I keep writing the wrong year consistently, but it's only 3 years away. So we have to pay attention to this. We don't know what it's going to come back down to. So it's something that, if you are above the 5 million, but not at the 13 million, we should take a look at it because we don't know what's going to happen. But for the most part, we should be so lucky to have an estate tax problem. But it's something on the federal wise, but most people don't have to worry about it. But we want to monitor to see what's going to happen. So I'm going to shift topics slightly, but are there any questions so far about the taxes before I move on to another topic?
Yes. I don't know if you can hear me.
I can hear you. Yes.
Oh, okay. My question is, what if the heir is in another state and you're in DC? Does that make a difference in what you just told us?
It does not. It's based on where you live.
Okay.
Yeah, it's based on where you live. If you are a DC resident, it's based on your estate.
Okay.
Any other questions? All right. So let's talk about, by the way, actually, while I'm thinking about this, if anybody in here has either you or your spouse, if you have any sort of interest in a business like an LLC or S Corp or anything like that, whether you own it or it's a partial interest, if you guys can either put in the chat or send me a message, because if there are anybody who has a business interest, I see a hand. Is that for the business interest here? Okay.
About the tax, I'm sorry, it just came to my mind. What if you inherit something from another state, say North Carolina? How would that, the reverse of the other question?
So it's based on the North Carolina estate tax law. I'm not licensed in North Carolina, so I can't speak to what that estate tax would be, but you're not paying the estate tax. It's before. So let's say the estate is $10 million and North Carolina has an estate tax threshold of 8 million. So, up to 8 million is tax free. Up from 8 to 10, they be hit with estate tax. So whatever your share is, you only get that after the estate tax has been paid. So it's going to be based on the North Carolina resident. And so it's whatever their estate tax laws are that will impact it.
Okay, thank you very much.
So it's generally not something you have to worry about. It's the person who passed away, their estate has to deal with it. So you're not going to really inherit something until after they've paid it.
Okay, thank you very much.
Sure. And if you guys just make sure everybody heard me, if anybody does have a business interest, either you or your spouse, please send me a message and so I can make sure I cover that. If there are no business interests, then I won't deal with it, but send me a message or put into the chat. All right, so we talked about estate tax issues. The big question people always ask me is, what is the right document to put into place if I want to leave money to people? So I'm going to give you guys another scenario here. So let's say you are leaving money to a combination of people. Maybe you're leaving money to adult children or to grandchildren or to a niece or nephew or a great niece or a nephew. What is the best structure to put into place? So I'm going to give you guys another scenario and you guys are going to tell me in the chat whether you think it's true or false. So I am leaving money to my niece who is 12, and a will is the best tool for me to use to leave money to my niece. So tell me if you think it's true. Tell me if you think it's false. I am leaving money to my niece who is 12, and a will is the best tool to leave money to my niece. You guys another minute or so to enter your answers. All right, so it's a little bit of a mixed bag. Let's talk first about what a will can do, and then we'll talk about what a will cannot do. First, I want to make sure we're clear. There are different kinds of wills. A lot of people think there's just one kind of will, but there's not. There's actually many kinds of wills. And so the will that's like a standalone will by itself is pretty different than the kind of will that's done with a trust. So let's talk about what a will does do. A will is where you specify who, and I'm talking specifically just DC law. It's different in each state. So we're just gonna talk about DC, which should be a state. So for DC, where we specify who the executor would be. The executor is the person who handles like the accounting, administrative reporting requirements. It's a very administrative type of role. When somebody passes away, the executor goes to the death certificate. By the way, I hear a dog barking. If people can just mute.
I'm sorry.
That's okay.
My dog.
If you guys can just mute yourselves and just take yourselves off of mute when you have a question, that would be great. Thank you. So you can leave cameras on. Cameras can definitely stay on. I like seeing faces. It's much easier to talk to faces than just names. So the executor is the person who gets the death certificate, and they bring the death certificate to the bank or to the life insurance policy, and they say, okay, this person has passed away, and the money pays out to the beneficiary. So it's a pretty administrative type of role. And then also in the will is where we specify if you have any charitable donations, if you have any pets, cats, dogs, or whatever, well, clearly somebody here has a dog, who's going to inherit the animal. I have a dog too. My dog heard your dog barking and was like looking around for the dog. Who's going to inherit the animal? People oftentimes leave money not for the animal, but for the person who's going to inherit the animal, so they're not financially inconvenienced by it. I had somebody the other day who left incredible amount of money for their dog to be taken care of. I'm like, what does this dog eat? Like, I buy my dog food at Costco, but apparently this dog eats like diamonds. I don't know. So, putting something like that in place to make sure the animal is taken care of as well. And then we also want to specify, if you are somebody, and I know we have a variety of people on this webinar, if you have a child who is a minor under 18, that's where we specify who the guardian would be. If you are not able to take care of the child yourself, that's where we specify who that guardian would be. The will, however, has restrictions, has limitations. If you are leaving money to somebody, and that money goes to them through the will, they inherit that money outright at 18 years old. So in my scenario, if I was leaving money to my niece who's 12, that money will go to her outright at 18 years old. So anytime money is going, whether it's a child, a grandchild, a niece, a nephew, a godson, whatever it is, anytime there is a potential beneficiary who is young and not necessarily even under 18, I usually say under 25, sometimes 30, that will inherit this money, you want there to be more than a will, because otherwise the will enables that child or that minor to whoever, or 20-year-old, to inherit that money at 18 years old and no strings attached. If that 18-year-old wants to take that money and go to Vegas or go buy a Lamborghini or something, they could. And there's nothing anybody can do to say, no, you need to save this money and use it for college or grad school or a down payment on my house, or, something like it's more responsible. And so anytime money is being left to somebody who's young, we want to think about having more restrictions in place. So you appoint a trustee who can be anyone. It could be your best friend. It could be your brother. It could be your lawyer, your financial advisor. It doesn't matter. It's just someone who you trust who's responsible for distributing this money to your loved ones for specific things until they reach a certain age. There can also be restrictions for adults. I talked to somebody this week who's leaving money to her sister, and she said, I want to make sure my sister is always taken care of and will have access to healthcare and housing, but my sister has a substance abuse problem, and I don't want to leave money directly to to my sister. I talked with somebody else this week who's leaving money to an adult child. The child is, I think, in her 30s, and the adult child has some mental health challenges. And so they don't want to leave money directly to her, but they want to leave the money to make sure that this person will be taken care of, but they don't trust that adult with that money. And so they appoint that trustee in perpetuity to say, I want them to make sure they're taken care of, but I also don't want that money being spent on things that it really shouldn't be spent on. So a trust can be used in so many different variety of situations to make sure that your money is going to where you want it to go to. If there are grandchildren in place, some grandparents say to me, well, I don't know if there's going to be more grandchildren or nieces or nephews or whatever. Do I have to update it each time? Like maybe there's another baby born. Do I have to update each time? How does that work? So to that, I say we automatically would structure it. So let's say you want to leave money to grandchildren and you don't know if there's going to be more. So you say, I automatically am leaving this money to my grandchildren, any grandchildren who are alive at the time of my passing. So if there are, no more grandchildren born, fine. If there's 5 more grandchildren born, fine. And it gives you that kind of long-term flexibility. So the documents really live and grow with you as your life evolves. We also will do it in a way that it says for charitable organizations. So let's say you're leaving money to different organizations. You want to usually do it in percentages. So I usually do kind of different pots of like different buckets. So 20%, and I'm making these numbers up, 20% of my assets is evenly divided among my siblings, whoever may be alive. If that sibling is not alive, then it goes to their adult children or grandchildren or whatever. This 20% of money is going to be divided among these 5 friends. This 30% of money is divided among these charitable organizations. As long as your percentages add up to 100%, we can always calculate who gets what. So that's the best way of doing it. I usually don't say, 5,000 here and 10,000 there, because we don't know how much is going to be in anybody's estate when they pass away. And so those numbers are never going to add up correctly. So as long as your percentages add up to 100%, it's always going to work together. So we also do a lot of if-then statements. If my mom is still alive, then I want to leave X percentage to my mom. If my mom is not still alive, then I leave this to my brother or, this organization. So a lot of these if-then statements can be really helpful. So with the trust, there's different kinds of trusts. The kind of trust I'm talking about is that I generally like, particularly in DC, is revocable living trust. So with the trust, there's 2 steps. This kind of trust, there's 2 steps involved. The first step is that we create the trust, and that's where you structure who gets what. Most people leave most of their money to their loved ones or organizations and things like that. So that's that first step where we do those percentages. The second step we do is called funding the trust. When I say funding the trust, we're not moving any money. All we're doing is changing beneficiaries of your assets. So for example, like life insurance or bank accounts, you have a beneficiary there, right? Right now, you probably have a beneficiary as an individual. That's what we're changing. Rather than the beneficiary being a specific person, instead it becomes your trust. And we change that on everything. So in order to change that, we have some forms that we can give you that you can fill out that says, I'm changing this beneficiary and it's now going to be my trust. So we do that for everything except for real estate. In real estate, if we're in DC, we would do a transfer with your deed. And we do what's called a deed of gift. A deed of gift says, I am giving a gift to my trust. And the gift that I'm giving to the trust is the house. It's almost like setting up a holding company. So here's you own the trust and the trust owns the house. You still own that house, but if something happens to the owner of the house does not go into probate, which we'll talk about in a second, does not go to an 18-year-old, but instead it flows through your trust to be distributed as per the terms and provisions of your trust. Does not change your taxes, does not change your mortgage. You can still sell it. You can refinance it. You can lease it. You have the same rights and responsibilities that you had before. Literally, the only thing that changes is how it's held in the DC Lands Records Office, which nobody ever sees. Any questions so far before I move on to a different topic? If a question is, if I want to cut a brother out of my will, will I recognize and acknowledge that I have a brother named to whom I leave nothing? If he should attempt to gain any of my assets, I deem these null and invalid. Will this work? So I wouldn't necessarily use that exact language, but there are ways to say that you want to disinherit your somebody in the will, and to say, and this is who I do not want money to go to. And then, the other thing I was going to say too was where I mentioned that we appoint like the trustee and the executor and a guardian. We usually want to have backups there as well, so that the backups can say, if for whatever reason this person cannot serve in that role, this is the next person in line. We had a case a couple months ago where our client passed away, and she had only named one person to executor and trustee and to all these different roles. And that person was going through some serious medical issues and did not want to serve in that role. And she said, I'm not doing it. And it's a big problem. So we would definitely want to make sure you can have that. So I saw a question, what does the word revocable mean in this? So revocable means that you can change it, you can modify it, you can amend it. You can also put something into the trust. So for example, like real estate, let's say you put real estate into the trust and then you want to sell that property. The act of selling that property is the act by which you are revoking that asset from your trust. And so you can modify it, you can change it. It's flexible. It can live and grow with you.
I have a question.
Yes.
I'm a senior who's on a fixed income and I'm on Medicare and Medicaid. If someone wants to give me a trust, will that affect my benefits and such, or my tax bracket?
So I don't know. I'm not that looking at Medicare and Medicaid. Not something I can advise on the person who's giving the money. I can't advise on the Medicare and Medicaid pieces.
Okay. All right.
Sorry.
Thank you. No problem.
I thought I saw another hand. To that question, there's another twist to kind of think about is if there is somebody who has any sort of special needs where they receive benefits from the government. So for example, my brother-in-law is 51 and he has cerebral palsy and is a quadriplegic and lives in a group home. He receives housing and healthcare because of his disabilities. And so in that scenario, where there is somebody in your life who has special needs and receives benefits from the government, we would want to create a separate special needs trust to ensure that person can inherit money, but it's not going to kick them out of their benefits, depending on if their benefits are income-based for special needs. So that is something that I am able to advise on. I saw a question here. When do you use joint tenant with the right of survivorship? So that's more about a property law question. I mean, if you're trying to put a house into the trust, by putting into the trust, then the joint tenant with right of survivorship is no longer relevant because you're now saying that it's going to be owned by your trust. So that will go away. That's not something we would really use with a trust. One of the other options in DC too is if you don't want to do a trust, but you do have property, you can do what's called a transfer on death deed. And that's where you're saying, like I did one recently where, this woman was leaving everything to her sister. And so we just say, this property is going directly to the sister. And she had very little assets other than the property, and it was all going to an adult outright. And so we did not do a trust in that scenario. And she just said, we're doing a transfer on death deed to have everything go. The property will go directly to her sister. And that gets filed with the DC Lands Records Office. I see a question here. Are there advantages to selling an out-of-state property and moving it to the trust? I'm not quite sure. Maybe you can take yourself off of mute and explain that question. I'm not sure what you mean about selling it and then moving it into the trust. Are you saying after you sell the property and then put the money, like the bank account going into the trust?
Yes. If two different states that it is possible I will be the heir to. Would there be advantages to maybe facilitating the sale now if that door opened to avoid the complication that you mentioned of these, say, a North Carolina tax law that I would know nothing about, that kind of thing?
So, first of all, if while somebody is alive, you have to look, they can't, while somebody is alive and then to give you something like that, we have to then look at issues relating to a gift tax. Because you can't just gift something to somebody while you were alive, even if it's like a parent gifting to an adult child, it would trigger gift tax issues. It's hard for me to say whether it would be advantageous or not, because I don't know if that person's estate, is going to trigger any sort of estate tax laws. So I think that, you have to look at the balance between the estate tax and like the gift tax to see if that is relevant. And I don't know North Carolina, but it's going to be based on the North Carolina resident and kind of what's in their estate.
Okay, it would be like an empty house, so no one's living in it, and it's no loss for them.
Right, but it's still an asset. If they're giving you an asset, then we're looking at issues with an estate with a gift tax that's being triggered.
That is true. Okay, thank you so much.
Sure. I'm going to put into the chat. I hope you can all see this. When I do these webinars, I get asked a lot of times where people have questions that they don't necessarily want to ask in front of a group. And so if there are questions that you have, I'm going to put in, here's the email. When I do webinars, I always offer a free phone consultation as well as a discount rate that I offer to people in the group. And so to take advantage of that, just send an email, and I just put the email down in the second line in the chat. And just send an email by the 25th, that's next week, and just mention this webinar. And then we'll set up a time to talk to be able to answer things that are more specific questions. Again, I'm licensed and my firm is licensed Maryland, DC, and Virginia. If you need a referral to an attorney in another state, so for example, like I know someone in North Carolina, that I can refer you to somebody in another state. And I say that everywhere. I mean, I have a network of people around the country. Hi, Sabrina, who I know, who I can make referrals to. So please let me know. One other twist that I want to propose to you, we talked about the special needs trust, is thinking about other scenarios that may be relevant in a family. So anytime there is a situation where there is a blended family, maybe there was a child from a prior relationship, or a parent or somebody has been divorced, or somebody has passed away and they've gotten remarried. That's a different type of situation. And it can be requiring a different kind of trust. I'll give you a scenario, and this happened in my family. When I was in college, my grandmother passed away. My grandfather got remarried, and I was in law school, and they updated their wills. And he died when I was in law school, and everything went to his new wife, who's going to live to be like 197. And, even it's not my favorite person. Oh, this is being recorded. So even like a lot of my grandmother's jewelry went to her. And, I don't know if it was intentional. I don't know if it was malicious, but it was really painful for people. And so it's something that when there is a blended family from whatever reason, whether it's been a death or a divorce, you have somebody you're leaving money to and you don't like the spouse. We all have those people in our family where I want to leave money to my brother, but I really don't like his husband. We want to make sure that we structure it a little bit differently. So if that situation that I'm describing is relevant for your family, let's talk about it, because it's a different kind of trust. For example, one of the things we could do would be what's called a QTIP. QTIP stands for Qualified Terminable Interest Property Trust. Cassidy, if you're able to grab this person who's just wrote in the console and keep track of that for me, that'd be great. So a QTIP is Qualified Terminable Interest Property Trust. And that's, you don't need to worry about this term, but it basically gives you the ability to say, upon my passing, I am leaving assets to my spouse to make sure they're taken care of, But when they pass away, it reverts back and comes back into my estate. So it does not go to their children or to their family or their siblings, but it reverts back and comes back into my estate to go to my loved ones. So it's a little bit of a different structure, but it definitely is something that we want to make sure that you know about those kinds of different options that are relevant for you. So we've talked about trusts. We talked about special needs trust. We talked about Q-tips. One of the benefits of a trust is that it gives you the ability to avoid probate. Just kind of showing your hands. Has anybody here ever been through a probate for a loved one? Yeah. What was that? You can take yourself off of mute. What was that experience like for you? Okay.
It was pretty straightforward because I had an attorney I trusted at the time, and he took care of everything for me. And it was not an elaborate estate. I guess it would have been considered a smaller estate. So actually, it wasn't that painful for me, but I worry about myself. So I'm thinking
Is
about
that person in DC, or where did that person live?
DC.
Okay.
And the attorney's passed away now, so I am looking. I'm worried about probate. I think I fall under everything else. It's the probate I worry about.
So you are lucky that it was not that bad. Probate in DC generally is kind of miserable. I'm going to give you guys a true false. I might be giving it away, but let's just consider this an easy one. So here's my true false. So get your fingers ready on the chat. So if I live in DC, probate in DC usually takes about 4 to 6 months.
Oh, I know the answer to that.
Don't listen to Caroline. She's not allowed to answer this one because she's been,
Okay.
she's not allowed to answer. All right, if I live in DC, probate takes about 4 to 6 months. I see two falses. Anybody else have a thought? Or you can just say, I don't know, too. All right, so I hope that, I'm sorry if I'm pronouncing it correctly, Sima or Sima. Sima is correct. It is more. Right now, it's actually closer to a year, sometimes 18 months. We've seen some that are 2 years since COVID. It's backed up things so much, but even pre-COVID, it was close to a year. Probate can be very expensive. It can be very time consuming. It can be really annoying. And, you know, I think part of the reason Caroline's experience was not so bad is because she had a lawyer who helped her with it. And so, but there's still legal fees that you have to pay to a lawyer to go through this. So if somebody says, I don't need a will, I don't need a trust, like I don't have that much, and my loved ones will just figure it out. They're basically saying, like, you who was the executor. So when we were talking earlier about different perspectives, like, is there somebody in your life who you'll be taking care of and you'll be inheriting from? Have this conversation with them, because if not, if they haven't taken care of their legal affairs, you are the person who's going to have to get stuck navigating probate for the next year of your life. So we want to kind of be proactive and have this conversation and say, I just want to help make sure things are taken care of. And we want to avoid probate. A will oftentimes is not enough to avoid probate in DC, whereas a will with a trust does usually avoid probate in DC. And we want to avoid probate. It's a gift you're giving your loved ones. One of the main goals behind these documents, it's like your life's Rosetta Stone, and you're putting in place things that will make it easier for your loved ones. So they're not going to have to spend money on legal fees and having to deal with documents, and things will just be simple and smooth. One of the best referral sources for me of places where we get new clients is when somebody has passed away and the person who's now dealing with it is in probate, and they're like, I never want to put my loved ones through this. So how can I set up documents to make sure my loved ones never have to go through it? And that's where the will with the revocable trust is generally the best tool to avoid probate. So all these documents comprise together what's called the legal estate plan. The legal estate, and if you guys have questions, feel free to put in the chat or take yourself off of mute. The legal estate plan is the umbrella term of what these documents comprise. The will and the trust obviously are big pieces of that, but there are a couple of other ones as well. And the will and the trust are significant. One is called a deed of tangible personal property. Tangible personal property is your stuff. Jewelry, china, family heirlooms, your guitar, your baseball cards, things that are important to you because they are worth a lot of money. Or for most people, it's the things that have a lot of sentimental value. I always kind of say, imagine your house was on fire. What would you run back inside to get? For most people, it's not, other than the individuals, it's not the expensive stuff. It's usually things that have meaning for you and your family. I think about that too, about what actually I care about. So thinking about who you'd want to leave things to. Now, of course, if you want to put down every single item of furniture and every single thing in your house, go for it. Most people don't. Although when my mom's father was dying, he was a Holocaust survivor, and he was very German, and he had this list that went on for maybe 25 pages, and it was like, this colander goes to this person, and we were like, oh my God, I don't want this. It went on forever. Yeah. So, you can do whatever you want with it. So that's what we do for your stuff. I want to shift topics for a second. So one of the things that I have been doing more in the last since the Dobbs Supreme Court decision, than anything, has been dealing with medical directives. And this is something that I can't emphasize enough. I'm going to give you a true false here and tell me what you guys think the answer is. So I am married. Therefore, I do not need a medical directive because my spouse can handle medical decisions for me. Who thinks that's true? Who thinks that's false? I am married. Therefore, I do not need an advanced medical directive because my spouse can decide things for me. All right, I saw Ari's first. So Ari, you're going to get my second gold star. So you are right. You guys are all right. It's false. Gosh, this topic is tough. I think you guys all know, like, I worry a lot about what the Supreme Court's going to do about same-sex marriage and whether same-sex couples will continue to have legal rights to handle things for each other. It makes me crazy. And so particularly ever since the Dobbs Supreme Court decision, my firm has been working with so many people to create updated medical directive documents that says, regardless of my marital status, this is the person who can handle medical decisions for me. And it's not just end of life things. A lot of people think a medical directive is, do you pull the plug or not? There's a lot of shades of gray. So for example, I have a lot of clients who say, yes, I do want to be kept alive on life support until my loved ones could come say goodbye, or for a certain period of time. With COVID, like, that was not something we ever thought about pre-COVID. What do you mean I can't say goodbye to somebody? That's a real thing since COVID. Questions about organ donation for any purpose, for saving the life of a loved one, for no purpose at all. Since COVID too, questions like ECMO and ventilators. And one of the worst conversations I have with people is when somebody says, my mom or my brother is having dementia or Alzheimer's, and so I need to get a medical directive in place to be able to handle things for them because I'm worried about their mental capacity. Gosh, I hate that conversation. It's one of the hardest conversations, because the question really becomes, does that person still have mental capacity to be able to sign a legal document? Is it too late? If they no longer have legal capacity to sign a document, we can't just have them sign it, even though they don't have that capacity. At that point, that person has to be deemed incapacitated. Trust me on this. No one wants to go through that process, whether it's for your parent, for a spouse, for a sibling. You never want to have to go through that process of demonstrating that person is mentally incapacitated. Use today's webinar as an opportunity to talk with your loved ones. If your parents are still alive, mom, dad, I want to make sure that no matter what happens, that I can take care of you and I can help handle medical care for you, and we're not going to have a problem. I always say to people, talk to your loved ones about this. I don't want to inherit a dime from you. Spend your money. You've worked hard for it. I'm not looking to inherit money. I am looking to make sure if I am your emergency contact, if I am the person who's responsible for your medical care, that I can do that for you and that I can take care of you, whether it's somebody who's older or the same age, I don't care. Have these documents in place long before there is a problem. And if somebody created these documents, 10, 20 years ago, it's time to update them. I'll give you some examples, like electronic medical records. That did not exist 10 years ago. Now that's the whole ballgame. It's not just simply saying, this is who I authorize to make decisions for me, but it's also, these are the kinds of decisions I want to have them make. This is like the scope of the authorization that says this person can also share medical records with somebody else, or, to be able to help take care of things. So put something like that in place long before there's any sort of a problem. Similar to the medical directive, we also would do the power of attorney. Now, some people say, well, what is there, a healthcare power of attorney? That's not really a thing in DC. Other states may have that, but in DC, it's not. So medical directive is for all things dealing with medical decisions. Power of attorney is for legal and financial decisions. Same idea, but for legal and financial decisions. Same thing, since Dobbs, I've been creating more of these than I ever have before, because you want to make sure, regardless of what the Supreme Court does, that your spouse can handle things for you and can make decisions for you if you need to. Now, it's not a carte blanche. Like if you're perfectly sound mind and body, they don't have that right. But if there's, God forbid, a car accident and you're in the hospital or whatever, or later on in life, if there is issues of dementia, that person who you've designated, whether it's a partner, whether it's a sibling, whoever it is, they have those rights. And we want to codify that in a document that is binding no matter where you go. This one particularly, I have a lot of couple of clients who will say, well, my family's from Alabama, and I am worried if my husband and I go visit family in Alabama and get into a car accident and we are in the hospital, that they're not going to recognize my right to handle things for them in a, somewhat state that's different. What happens then? That's where these documents are so imperative to make sure that no matter where you are, no matter what the law says, whoever you love has that right to be able to advocate for you, to be able to make decisions for you, and to handle things for you. You need to have that ally there, and have that ally has those legal rights to be able to handle things for you. So that's what we would do for power of attorney. Again, if you created these documents 10 years ago, let's update them. There's things that have changed. I'll give you another example of something that's changed. 10 years ago, there's no way your power of attorney included things like digital accounts. How much of your life is based on some sort of password? Everything. So does your power of attorney say the scope of the authorization? Again, it's not just, pull the plug or, like I'm in charge. What is the scope of the authorization that you have? So I saw a question here in the chat, where are medical directives and power of attorney documents filed? So they're not. The only thing that gets filed that we've talked about would be that deed of gift for real estate property that gets filed with the DC Lands Records Office. The rest of these do not get filed. What I recommend is that, you keep a copy of them at home in an unlocked, box that somebody can access if they need them. I would recommend you give them to the people who you appoint, whoever you appoint as your medical directive or your power of attorney, and the backup too. You're going to have backups. You can even have multiple levels of backups. First person is my spouse. Second person is my best friend. Third person is, I think, my cousin, so having multiple levels of backups, and each of them has a copy of that document. I would also recommend uploading them to whatever you use. So it's Dropbox or Google Drive or whatever it is. So how my phone's sitting here. So how like on your phone, you have, and most people have like the ICE, in case of emergency. So if you were in a car accident, the paramedics know how to go into your phone and they can pull the in case of emergency contact from your phone and to be able to access that. In that contact, I have a link to my my Google Drive that would bring them, and anybody who has that link, you have to have the link to be able to access it. and they can pull up my medical directive or power of attorney. If I was incapacitated, but had my phone, which I always have my phone, that they can be able to pull that up. If I was alone and incapacitated, they can pull up that document. And I actually have used that Google Drive document a couple of times where I've been traveling or something and something came up and I needed to be able to access it, and I was able just to pull it up and use it, in the hospital or wherever you are. They look at me like I'm slightly crazy, but I'm a lawyer, I'm kind of used to it. So that's another way to make sure you always have it and have it accessible, and that other people in your life have that as well. Any other questions so far? So there's another twist that I want to put on it, is that if you have somebody in your life who you are the emergency contact for them, and they are maybe young, so 18 to 30, you want to think about talking with them about having them create a medical directive and a power of attorney. Because if you are the person listed as the emergency contact, even if they are on your insurance, even if you are paying tuition or whatever, your rights once somebody turns 18 to be able to take care of things for them effectively end. And so I would say, the same way we're talking about multi-generations, like talking about it for your older relatives, same thing will be true for a younger relative. If somebody is 22 and they have you listed as their emergency contact, that's great, but you don't have any authority to be able to make decisions or to handle something for them. So once they turn 18, your rights really end. So, have that conversation. And again, I put into the chat earlier that I'm offering a special discount and free phone consultation. If you send somebody to me and they say, I was referred to you by this webinar, I'll talk to them for free and have that conversation too. So we're going to start to wrap up, but I'll put this in here one more time in case somebody didn't get it before. If you guys want to send me an email, I'm happy to talk with you all. So, we've talked a lot about power of attorney and medical directives. When you're working with a professional, whether it's, a CPA or a financial advisor, first of all, if you need referrals for people who are LGBTQ supportive, I have referrals for you guys. So feel free to email me. I'll put my actual personal email in here as well. The consults goes to my assistant who handles that stuff, but I'll put my personal email in there too. If you need a referral for anything, this is something I'm happy to connect people with. I know one of the most challenging phone calls I get is when somebody says to me, are you willing to work with an LGBTQ person? And it breaks my heart because it's terrible that somebody has to ask that question. But I understand it. And I am a believer in trying to find a network of people who are professionals who can be supportive for people in your community through on Capitol Hill, and can help you guys with navigating whether it's legal issues or financial issues. So I'm happy to be an ally and to be a supporter for helping with a network that you might need for these different contacts. When you're working with somebody, it's important to find somebody who will do two things. One, somebody who will answer your questions, and also somebody who will ask you questions you don't know to ask. I find for a lot of my clients, one of the most important roles that I serve is that you don't know what you don't know. And that sounds silly, but I think there's a lot of truth to it. And that's where I find that the good lawyers are going to help you kind of plug some of those gaps. So, I'm going to start to wrap up. If you guys have other questions, feel free to pose them in the chat or take you off of mute. But, we've covered a lot of topics today. And we've kind of just touched the tip of the iceberg, but I hope that it's given you a sense of what's involved with these things. What are some of the things to think about? There's what you read online is oftentimes not relevant or not accurate, particularly for DC. DC law can be different than a lot of other jurisdictions. So we want to make sure documents are current, they are comprehensive, and they are customized for your specific situation. So I saw a question.
Yep.
Yes.
One question I have is, most of us in the LGBTQ community are single for the most part. And how do we, because families may have rejected us or we've rejected the family, and at our age, a lot of us are alone because our friends have passed away. What can you suggest for us getting someone to do that for us, like the executor or whatever? And it's easy to say, choose your best friend, but your best friend may not be oriented toward legal documents and so forth. So what would we do in a case like that?
It's a great question. Thank you for asking that, Wes. So I have a two-part answer to that. So it depends on what the role is. So for example, if it's the executor or the trustee, you can have a corporate executor or trustee. So for example, like the lawyer that you're working with, like my firm has served as executor or trustee for a lot of our clients. Some people might put us at the backup executor or trustee. Maybe you might put a friend as the primary. And then you're like, if that person is not available or alive, then this is the backup is the Geller Law Group. And my firm has done that for a lot of our clients. You could also ask, let's say you have a CPA or a financial advisor. They may be willing to do that as well. And so, that would be one option, particularly for the things that are financial related, like the trustee and the executor. That's really something that a lot of law firms will do. I am not, however, going to be somebody's medical directive person, because I think that is somebody who does need to know you, and they need to know kind of what you would want. And so that's where, you can talk to, that's a different role than the executor and the trustee would be, because the job of the person who's handling the medical decisions and the power of attorney decisions, the idea is they are doing things in your best interest of what you would have wanted. And that's hard for somebody like me to do when I don't know someone that well personally. And so that's where I would say talking to, whether it's a friend or somebody in your community who will be able to kind of help take care of something like that for you. And I think that's probably, or, is there a social worker who you've worked with, or, something like that, or even a doctor sometimes might be willing to do that for medical decisions. So those are the kinds of things that that's how I would handle it, but I know it's tough.
And in conjunction with that, something new, doulas. Are you familiar with death doulas and so forth?
Absolutely.
Can you speak to that particular issue and wills and trusts?
So, a death doula is something that you can put in saying that you just want somebody there to help with that process. They're generally, they don't have any sort of legal role or legal standing. And my firm has represented some doulas in this role. And so usually when you have a death doula, they have an agreement that you will sign that says this is what you want that person to do, and this is what role you want that person to handle to be for you. So it's really going to be more in your agreement with that person to be able to figure out what capacity and what role and the scope of the work that they're doing for you. That's not usually something that's in the will or the trust. However, you could put it in like for the medical directive and say that you want this death doula to be there as part of end of life decisions.
Okay, thanks.
I saw a question from Barbara, but I'm not sure I understand it. It says, "What are you, Keller?" I'm not sure what that question is asking. If Barbara if you want to go off of mute and clarify that question.
Well, she said that's me, LOL, and I didn't know what she was referring to herself as.
I believe that's when Rebecca had mentioned that the emails go to her assistant and then Keller.
She's her assistant. Oh, I just wondered I just wanted some clarification. Thanks.
Any other questions? Carolyn, I think you're talking, but I think you're on mute.
Unmute. Thank you, whoever sent that. My partner has been diagnosed with vascular dementia, but isn't totally gone, is able to think somewhat on her own. Is that person too far gone to make some of these decisions?
I'm sorry to hear about that with your partner. That's tough. I don't know. The question would be, their physician would have to make that determination. The physician will be the one who can say whether that person has the ability to enter into an agreement. And there's some questions too, because, some people who do have dementia are fully alert and cognizant of everything in the mornings and not so much in the evenings. And that's very common. And so as long as the physician's able to say, we are able to identify, yes, this person can make legal decisions, I defer to the physician to be able to make that determination of what, whether somebody can enter into a legal document.
Okay, I don't have that many. That transfer on death deed, though, sounds very good to me. Since all the property's in her name.
Yeah, I mean, the
Very selfish.
transfer and death deed can be helpful when you're leaving it to one person. The drawback of a transfer and death deed is that there's no backup plan. That if, let's say there's two people and one's leaving it to the other one, and God forbid you're both in a car accident together, what happens to that property? So that's why I oftentimes like the trust better, and doing the trust with the deed of gift, because the whole thing is that we want to have a big picture plan. We want to have a big picture plan about what's going to happen and the what ifs and the different contingencies. And so that's where a trust can be really helpful to think about long-term if then types of things.
Right. Well, I'll be in touch because I'm worried about the probate.
Yeah.
I think we come in under all the other limits. It's that probate that's out there at the back of my mind. I don't want to have to liquidate everything, especially in a market like this.
Well, and probate is it's just not a fun process. I mean, you had, I think, an unusual, maybe this was a small estate. And DC was just maybe different then, because DC courts are not the greatest right now.
Right.
One more question.
Oh, go ahead.
Go ahead, Carol, finish.
I'm just saying, as far as I know, I'm the only one. And since I know where all the documents are, I haven't seen any other names listed. So it's just going to be me, myself, and I. I mean, people can come out of the woodwork, I guess.
Well, and sometimes that has happened. I mean, we've seen it where all of a sudden somebody comes up and is like, oh, well, I lent her $25,000 5 years ago, and I want that back in my inheritance. Well, where's the proof? And,
right.
So many scammers out there, and we want to be careful with it. And unfortunately, they do tend to go after senior citizens, and it's something we want to make sure we can protect from that.
Well, we are legally married, not that, as you say, that could, who knows what's going to happen.
I hope it does not change, but I wouldn't put anything past the Supreme Court. So,
well, I will be contacting you. I've taken enough of your time.
Oh, sure. No problem. Wes, go ahead.
Is there any value I've heard of couples doing it, same-sex couples, adopting each other for legal purposes? Have you heard of that? Or
yeah, it's not really going to give you any more protections. I mean, right now, obviously marriage is legal, and that's our best tool. And obviously we hope it stays legal. But if for whatever reason it changed, the medical directive and the power of attorney documents is what will give you the same legal rights to be able to make decisions for each other.
okay.
They can't change like inheritance laws, because that's going to be there no matter what. I mean, you can leave money to whoever you want to leave money to, whether it's, a partner or a best friend or a brother, doesn't matter. It's more about the issues that come up. And this has come up so many times where somebody's in the hospital and the, doctor is a bigot who is saying, nope, you don't have standing, you don't get to make these decisions. And that's where this legal document says, yes, I do. No matter what the Supreme Court says, no matter what your narrow mind says, this document gives me that legal right. And there's nothing they can do about it.
One thing I do when I have to go in the hospital for any reason, I will list my contact person. Usually I have 2 of them, but I list my contact people as cousins, which makes them family. And a lot of times the hospitals and so forth will say to you, well, if it's just a friend, we can't give out information. But if you list it as a cousin, which is family, they are more likely to listen to you.
Well, I'd rather you be protected more than that, to be honest. I'd rather you have that like you can, so when I had my kids at Sibley Hospital in DC, and before I knew I was going into the hospital. And so I was able to file my medical directive on file with the hospital. So they had it. Because, and look, I'm absolutely that crazy lawyer mom who, like, when I'm in the hospital and they're giving me their medical directive and I'm, lining up, writing, crossing through things. And I'm like, no, this is not how I'm signing this. Their documents that they will make you sign unless you have your own. Their documents are not great. They're very, and Sibley Hospital is a great hospital, and their legal documents are not so good. And so I'd rather you have a document that's made for you and set. It doesn't matter if that person's a friend or a partner or a spouse or a cousin, I don't care. You choose who you want making decisions for you, and you can put it in that document. This is the first person. This is the second person. This is the third person. And that is going to override anything that you put in place. If you say this person's a cousin or whatever, there are better tools out there to make sure you're protected. I have a lot of strong feelings about this. I want to make sure people are protected. I've seen it happen, and I've people in my family who have been discriminated against. And it's very, very frustrating. Well, I'll turn it back over. If there's no other questions, I'll turn it back over to Sophia to wrap up. But really, really great meeting you all. And I'll send an email to Sophia as well that she can circulate to the group with the follow-up. It has my contact info as well. And if I can be helpful, if I can be a resource, even if it's for anything, if somebody has a car accident and they need a personal injury attorney, it's not me, but I can give you a referral of somebody who I trust. So feel free to keep my email at any time I can ever be a resource for you. Please don't hesitate to reach out, and I'm happy to be there for you guys. So nice to meet everybody. Thank you again, Cassidy and Ari and Sophia, for having me today.
Thank you, Rebecca. And I will be sending out a follow-up email with the recording as well as the information you shared, so folks don't have to stress out about writing all that down. Okay, well, I hope everybody has a great rest of your day, and we'll see you at future programs.
Have a good weekend, everyone.
Thank you, Rebecca. You've been great.
My pleasure. Nice to meet y'all. Have a good day.
All right.